Global Webinar Channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with eDiscovery. Today's Doug Austin, and it's called the Important eDiscovery Case Law Decisions for August 2023. Our faculty experts are, of course, Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the Counsel, and questions will be answered during and at the end of the webinar. This webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstead, EDRM's Chief Strategy Officer, is here today with us. Could you please tell us what resources are available?
Absolutely, and so excited. I count down the days every month for this, what I call a cult classic. Great presentation. So, as an introduction to the platform, there are many, many more ways to engage on On24. You'll note there's a media player where you can see video. Question mark is where you type your questions in for the faculty to answer. The slides will be available after the webinar has concluded. And if you click the paperclip, that's for related content. And today you'll see engagement tool descriptions for you to download to help you better engage, a link to learn more about the Honorable Judge Peck and how to engage with him. And you can check out Tom O'Connor's spicy new book, eDiscovery for the Rest of Us, and save your seat for next month's Case Law Edition. And up next on EDRM's webinar channel, September 6th, don't delete that. How to preserve AI, social, text, and collaboration apps for litigation. Click the link to save your seat. Speaker bios can be clicked and popped up to learn more about today's faculty. And the latest news is where you can subscribe to EDRM's weekly newsletter and never miss a thing. And just like Zoom, we have emojis. You can click the smile face, love, whatever you think or however you feel, and we highly encourage you to engage with them. The Twitter bird is to follow EDRM on LinkedIn, and you can follow eDiscovery Today on LinkedIn. You can also contact EDRM via email. And back to you, Mary.
Thanks, Kaylee. I love those engagement gizmos. Now, to get into it, we've got Doug Austin. Doug Austin is the founder and editor of eDiscovery Today. He is an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, and technical project management services to numerous commercial and governmental clients. Doug has published a daily blog since 2010 and has earned J.D. Super Awards 3 times. And we also have, of course, the Honorable Judge Andrew Peck. He is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters. He also serves as a resource for the firm and its clients on litigation strategy and discovery issues from a judge's perspective. Judge Peck retired as a United States Magistrate Judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions and later boilerplate objections, 502D orders, and technology-assisted review. And the spicy Tom O'Connor, hailing from the great city of New Orleans for over 3 decades, Tom has stewarded the Gulf Coast Legal Technology Center, and as Kaylee said, he's written a new book on eDiscovery for the Rest of Us that you can find on his Techno Gumbo blog. And with that, Doug, I understand we have a boatload of cases.
We do indeed, Mary, and thanks, and hi everybody, and welcome to our second case law webinar in August on the EDRM network. We do that once in a blue moon, which is appropriate because that's happening tonight as well. And we do have another set of very interesting cases this month, including a motion to compel a forensic examination of devices, a request for discovery on discovery with no ESI protocol, production of hyperlinked documents and metadata for email threads, sanctions for a wiped laptop after termination of employment, another sanctions case involving 2 email purges during duty to preserve, and finally, in a case involving illusion testing and production of follow-up search results. Just a reminder, we do welcome questions, and I'll try to get to as many. We'll try to get to as many as we can, and we will send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. The weather may be hot, but disclaimers are always cool.
Oh boy.
Indeed. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 31,700 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So, with that said, let's get into the cases. Our first case is a breach of contract and misappropriation of trade secrets case, where the plaintiff served the defendants with the first request for production of documents, which included a request to produce any cell phones, computers, and other electronic storage devices from March 2022 to the present for forensic inspection and imaging. Defense counsel at the time, who subsequently withdrew, seemed amenable to producing various devices and storage media, but no production was ever made. Instead, all but one defendant objects as the devices include confidential business information, proprietary information, or trade secrets. So the plaintiffs filed a motion to compel. In his analysis of whether to compel a forensic examination, Florida Magistrate Judge Kyle Dudek stated, when determining whether a forensic examination is warranted, the court must weigh the utility of the proposed examination against inherent privacy concerns. Also relevant is whether the parties withheld requested discovery, will not search for requested discovery, and the extent to which the parties complied with past discovery requests. Mere speculation that electronic discovery must exist is insufficient to permit forensic examination of a party's personal computer or cell phone. He also cited the Middle District of Florida Discovery Handbook, which stated that inspection of an opponent's computer system is the exception, not the rule. Judge Dudek also stated the motion also falls short for a more fundamental reason. It's premature. Plaintiffs seek a forensic examination to discover if defendants downloaded files onto a storage device or sent confidential information to their personal mail accounts. But plaintiffs have not first requested that defendants voluntarily produce such information. In other words, plaintiffs have not gone through the discovery process necessary before obtaining the exceptional relief of a forensic examination. The plaintiffs also didn't identify the forensic expert, expected the defendants to identify the search terms, so Judge Dudek stated in denying the motion, plaintiffs' request is based on mere speculation, which is not enough. So, Tom, if the plaintiffs had done a better job of filing a timely, well-considered motion, do you think the motion would have been granted?
Well, I don't know if they had met both of those standards, it would automatically be granted, but certainly it's not going to be considered unless they do that. As you said, there were two things at play here. One, as the judge said point blank, the motion was premature, and you know, he laid out what they needed to do in terms of the discovery process first. And then in the last paragraph on the slide there, he laid out the problems with the motion, which were substantial. So I guess you say, if by well considered you mean something that actually laid out a real reason why there should be a forensics examination, yeah, but certainly it had, it's got to be timely, and it's got to meet the standards that the judge laid out and the procedure according to the Discovery Handbook in the Middle District of Florida that he also referenced. So a lot of things wrong here.
Indeed, and certainly that was instrumental in the decision. So, Judge Peck, would you have ruled the same way, including denying the motion without prejudice? And what factors, when you were a judge, did you consider on whether to deny with or without prejudice?
Well, first of all, as to would I have ruled the same, yes. Possibly, if they had made a better showing, one might have ordered imaging, with the imaging to be held by defense counsel to see later on if it was necessary for some reason. Because in trade secret cases, the issue of movement of data is often significant. As to the with or without prejudice, that's standard practice. If a motion is denied with prejudice, that basically means it cannot be brought again. So when something is denied in part as premature, if the court had denied it with prejudice, then they could not have brought it later on if the defendants, fooled around and didn't comply with discovery. So this is a perfect example of denied without prejudice to bringing it again with the right information, the right need for the relief requested, et cetera, et cetera.
Yeah, absolutely. So obviously, Mary, as we've just talked about, the plaintiffs clearly made several mistakes in requesting the forensic examination. So what advice do you have for our audience on when and how to request forensic examinations in litigation?
Well, it's pretty clear from this case you don't ask for the examination from the beginning. And I agree with Judge Peck that in trade secret, or if you want to expand that to things like fraud or instances where the IT department is involved or something like that, you may want to get imaging done right away. And Judge Peck, what's the mechanism for that? Like, you send a preservation letter over requesting imaging and requesting that they hold it and basically say, we're going to ask to prove that you didn't take, that our material did not come from our servers and be resident on this computer and blah, blah, blah. What's the mechanism to force that?
Well, the mechanism is to go to court and get the judge to require the imaging.
Now, as a preservation option, or as right in the beginning?
Yeah, I mean, once you're in court, you can do that. Again, the judge would likely say, why do you think these people are going to be bad actors and destroy information or evidence that a thumb drive was inserted or any of those sort of things? So you need something more than this is a trade secret case, image all of their devices. Also helps if one is willing to pay for that as opposed to imposing the cost on the defendants.
Yeah, I think it's a catch-22 because I think you do need to ask for it early, even before you've got active data requested and produced, evaluated, and then find something missing. If you ask for forensics 2 years down, it's going to look a lot different than forensics in the moment.
It's sort of the Goldilocks principle. You can't ask for it too soon or too late. You got to hit it at the right time.
Yeah, absolutely. And I expected a couple of you would mention the fact that this being a trade secret case, these cases are the ones that tend to be more aligned to needing forensic examination. So it's certainly interesting from that standpoint. I got a comment here, but I'll try to get back to it here so we can move on, get through the cases. So our next case honestly didn't get off on the right foot. In this patent infringement litigation over automotive parts, Illinois Magistrate Judge Sunil Harjani opened his order by stating, the question the court explores in this opinion is, what is the authority and the standard for permitting discovery on discovery? Discovery production is akin to an honor system. As a general rule, attorneys do not second-guess each other's processes for producing responsive information. Well, they do in the cases we cover, but that's beside the point. The reason the case got off on the wrong foot is that when the parties submitted their joint initial status report in August 2022, they stated they do not anticipate any electronic discovery disputes at this time, to which Judge Harjani stated famous last words, Unfortunately, and before this court's involvement, between August and November 2022, document production proceeded and the parties did not agree on an ESI protocol, nor did they ask for the court's assistance in establishing an ESI protocol at the start of discovery. Whoops. So when LKQ wanted to require Kia to enter into or follow an ESI agreement, the court instead required the parties to file separate ESI disclosures describing their discovery process, as you see in the third bullet point there. When LKQ reviewed what it received, it served a Rule 30b-6 deposition, which appeared to be directed at Kia's ESI disclosure and their document collection efforts, which was essentially a request for discovery on discovery. Regarding LKQ's assertion that Kia's ESI disclosure did not properly identify custodians, Judge Harjani stated, the court did not define the meaning of custodian generally. Accordingly, because Kia's disclosed identities of its custodians by group are sufficient, the court will not compel Kia to provide the individual custodians' identities. Regarding LKQ's assertion that Kia's ESI disclosure did not disclose the search methodologies it used, he stated, the court stated that keyword searches were not required and custodians are perfectly capable of looking for documents and producing documents. Therefore, Kia's disclosure of its search methodologies is sufficient, and the court denies LKQ's motion to compel Kia to provide additional transparency or a Rule 30b-6 designee. Judge Harjani also rejected their request that Kia produced its litigation hold memos, stating, LKQ again provides nothing more than mere speculation that Kia did not institute a litigation hold in this case. So Judge Peck, last month in the Lyman versus Ford Motor case, Judge Stafford required Ford to be transparent regarding its search terms and methodology. So what's different about this case?
First of all, two different judges. We can have different views of similar facts, but more helpfully, in Lyman, there was clear evidence of employee self-collection and very limited production from the key custodians, and counsel in front of the court, which is always a bad thing, was very vague as to what the search methodology was that Ford was using. Here, no specific evidence of a failure to search in good faith. It sounds to a certain extent like the employee self-collection here was finding clearly identifiable documents, not going through search terms or the like. I may be reading too much into what was said there. But, no evidence of a failure to search in good faith. Also, a 30b-6 deposition on discovery is a fairly terrible way to get that information. Who is doing the searching and what search terms? Many, if not most of those decisions are counsel's decisions. So you're going to come very close to invading work product or attorney-client privilege if the company puts up one of its lawyers as the 30b-6 witness. If that sort of discovery on discovery information were needed, should be produced in an affidavit or an answer to interrogatories or something. So wrong way to try to go about it.
Yeah, absolutely. And Judge Harjani also mentioned Sedona Principle 6 as a part of this discussion as well as chastising the parties numerous times for not having that ESI protocol up front. So Mary, another comparison of this case to last month's Lyman versus Ford Motor case is that it also seemed as though Judge Harjani was endorsing self-collection when he said custodians are perfectly capable of looking for documents and producing documents. Do you agree with his decision there?
Well, I'd like to. I think it sounds good. But I do think there needs to be oversight of what's communicated to the custodians. What are they looking for? Is there a place they can go for questions? And then even more importantly, what do they do with the documents when they find them? Do they just drag and drop them across technical lines and change their create dates. What do they do with it? But the thing that really surprised me in this case is that they didn't identify the custodians by name. They identified them by group, so there would be no way to even like follow up on an individual basis. I haven't encountered that before.
That did seem odd. Yes. I mean, I can see when you're talking like a department like IT, but groups a little bit different. So yeah, there were a couple of things about this case that were kind of interesting. Certainly, Tom, you reached out to me about this case, and I forgot to mention that both Judge Peck and Tom recommended this case for us to cover. So, Tom, when the parties indicated they didn't expect disputes, should the court have been more proactive and pushed them toward an ESI protocol anyway?
Well, I mean, that would have been great, and you kind of think, given the discussion, that perhaps he would, except that, as you noted in the second bullet point, they entered the report with that statement that they didn't anticipate disputes in August of 22, and the judge noted that the production between August and November of 2022 was before the court's involvement. So it sounds like they entered into the agreement, filed it, disputes didn't start to pop up, and the magistrate judge didn't enter the fray until downstream. Would the judge have pushed them? Yeah, I mean, I think that would have set off some real warning signals. Like, wait a minute, you got a case involving a major automobile association or a manufacturer, and you're saying there's not going to be any disputes, and you're agreeing to productions without a protocol. It's like warning, danger, Will Robinson. But if the judge didn't come in until, past that point, then the judge is kind of stuck with doing what the judge did, right?
Right. Yeah.
Just if I can piggyback on that for a minute. I mean, lots of cases, the lawyers, when they're filing their early 26F report, are saying, we don't expect any problems. One should always take that with a very severe grain of sand. On the other hand, there's lots of literature and thoughts that ESI protocols that take forever to negotiate and that, deal with issues that may never come up in the case, but if the parties are doing the ESI protocol, they want to cover anything that could possibly go wrong, except for the things that later do go wrong. So, I'm not sure what the judge could have done. And I suspect if the Northern District of Illinois is similar to Southern District of New York practice, the district judge conducted the 16B conference, and until there were disputes, did not refer the case to the assigned magistrate judge. So the magistrate judge here had no reason to be involved until later on.
Right.
Sure.
I will say, David Edelman has entered a note that must have appeared in this court that Magistrate Harjani has a model ESI protocol order as a charter member of the eDiscovery consultant school, who typically is working with requesting parties in this sort of matter. I always tell my clients, either have a proposed model order of your own that you send out immediately, or look and see if the court or the judge has one, and get that teed up immediately. To go in and say that you're not going to have any disputes, again, warning, Will Robinson.
Yeah, absolutely. A great point on that, Tom. And Judge Harjani did mention reference his model ESI protocol order in this order. So, and it's notable there. And certainly another comment about dismissing ESI protocol seems to happen all the time in state court, not so much in federal court. And maybe it shouldn't happen. And certainly, this is a good lesson learned for the importance of an ESI protocol up front. So certainly worth noting there. We'll move on to our next case, which involves a couple of hot topics, one of which has been discussed and debated pretty extensively the past couple of days on a LinkedIn thread I started. This case involved 7 consolidated cases involving a tracking tool known as the Metapixel, through which the defendant allegedly received the health information of millions of Facebook users. The court's order very briefly addressed proposed ESI protocol disputes regarding the handling of hyperlinked documents and producing metadata for email threads. In fact, this slide shows almost the entire order. Regarding hyperlinked documents, California Magistrate Judge Virginia DeMarchi stated, "The court is persuaded that the commercially available tools plaintiffs suggest may be used for automatically collecting links to non-public documents have no or very limited utility in Meta's data environments or systems, and even that limited utility, which was Microsoft Purview eDiscovery Premium to collect links to SharePoint and OneDrive cloud attachments, would disrupt Meta's standardized workflow for ESI-related discovery processing across all of its platforms and systems. Accordingly, the ESI protocol should make clear that hyperlinked documents are not treated as conventional attachments for purposes of preserving a family relationship and production. However, the court anticipates that for some documents, it will be important to collect or attempt to collect hyperlinked documents and associate them with the underlying ESI in which the links appear. In such circumstances, the parties should consider reasonable requests for production of hyperlinked documents on a case-by-case basis. Such requests should not be made as a matter of routine. Regarding the production of metadata for email threads, Judge DeMarchi stated, "The court finds that the benefits of the approach plaintiffs suggest do not outweigh the burdens of what would be required to provide the additional metadata information. This is particularly true here, where a party is only permitted to produce the most inclusive message and avoid separately producing the earlier messages in the email thread when all thread members are fully contained within the most inclusive message, including attachments and identical senders and recipients. Thus, with the exception of the send date, the metadata for the most inclusive message should reflect all the same participants for all earlier messages in the email thread." So, Mary, this is the first case we've seen that I know of where a court has ruled on the treatment of hyperlinked documents without an agreed-upon ESI protocol beforehand to help guide the ruling. Do you think she got it right in ruling that hyperlinked documents should not be treated as conventional attachments?
I don't. I think in a technical sense, they're certainly handled differently all through the EDRM. The attachment is stable and sort of contained within the email. The hyperlink is not. The link is there and it goes to an external storage for for its storage. And so you've got some preservation and information governance challenges because the file underneath that hyperlink can change. Link shorteners, how do you collect it? How do you display and produce it? So I don't think she got it right because we've got, let's see, the stored in any medium from which information can be obtained either directly or, if necessary, after translation by the responding party into a reasonably usable form. So these are the same arguments we used against attachments in the early days of email, and we're all producing attachments, and I think the linked documents are important parts of that communication. So no, I don't think it was decided right.
All right. And the debate continues because I've seen a number of people on both sides of this issue in the discussion thread I've got going on LinkedIn. So very interesting. So Tom, Judge DeMarchi said that with the exception of the send date, the metadata for the most inclusive message should reflect all the same participants for all earlier messages in the email thread. But doesn't the lack of a send date of the interim messages within the metadata shift the burden to the requesting party to determine the timing of communications?
No. I mean, why wasn't the metadata preserved? Isn't that the obligation of the producing party? Whether they're required to, preservation and production are two different things. Where'd the metadata go to would be my question. But this is, I don't want to get into a whole thing about this hyperlink argument because that's a rabbit hole that we could go down that. We could go down that rabbit hole for the next 3 hours, I'm sure. And I'd really suggest everybody take a look at your thread on that online because there is some great discussion going on, and I think the gloves are going to come off pretty quick with some of the people involved. But this is an area where, as Judge Peck pointed out on the prior case, is the protocol going to help? Is a protocol really going to do what you need to do at the right time? This is a huge issue, but certainly this is one that should have been discussed at the meet and confer and ironed out ahead of time. I don't think dumping it in the magistrate judge's lap, and I tend to agree with Mary that I'm not sure the proper decision was made here, is the way to go. I'll also note, again, because I typically represent or work with requesting parties, the use of the phrase, this is not an industry standard practice, is one of the prime examples of the new type of boilerplate language we see. If I see that in a response, I always tell my clients to ask exactly where that industry standard practice has been published or promulgated so that we can refer to it. What organization, rule maker, or legal body has promulgated such an industry standard practice. And in fact, they admit themselves they did it in a prior matter. So how standard is it if they can do it when they want and do it when they don't want? So that's all I got to say about that.
I'm sure there's plenty more to say, but great point. Yes, that industry standard document isn't really, just readily out there. So
Yeah.
Certainly notable. And I'll certainly mention a couple of people have pointed out, one has said the document that's linked is arguably not the document that was quote unquote attached at the time the pointer set was sent. That's certainly true. Technically, email attachments are embedded files within the message, where hyperlinks are not embedded files, but pointers to a document elsewhere. And right. And one more comment: when review is performed, then a hyperlink is associated to a family, or is it a standalone file where counsel can make arguments? I think Judge DeMarchi is wrong. So, comments on both sides of the issue from the audience as well.
Yes, this is a heated area of discussion, right?
Indeed. And like you say, we could spend the rest of the time on it, but I'll move on and ask Judge Peck a question which might have maybe helped in this case. Certainly, I like a short ruling as much as anybody in terms of the work it saves me, but shouldn't Judge DeMarchi have provided a little more background to support her rulings on these two issues?
Sure. And then when we get a case like DR Distributors from Judge Ian Johnston, we all bitch that it's 200 pages long and et cetera, et cetera. But on a more serious answer, the judge's job is to rule on the case in front of him, or in this case, her, period. It's nice when there is time for the judge to do something for the eDiscovery industry writ large, but we're not academics. We're ruling on specific issues in front of us. When parties come in saying we're trying to put our ESI protocol together, we've got these two issues we need you to rule on, Judge. Getting a quick opinion out there to get the parties moving along is really what the judge's job to do. When you can get more background and information, that's obviously going to be helpful to the greater ESI eDiscovery community, but it's not a requirement of the judge. One other point, and I think one of the people from our audience mentioned it in the comments here, and that is on the metadata for threads side of things. No, it is not clear that everybody who was involved in any of the intermediate parts of the thread is going to be in the final to from CC list. So that's one thing here where I think putting aside, what date was something sent? Okay, that's one thing. But is there metadata for all of the participants in the lower parts of the thread? And I don't think that is true in every case.
Right. Yeah. And I think in this case, it seemed to me like the parties must have agreed to produce email, only the inclusive email, provided that all the senders and recipients were the same throughout. So it wasn't a case. Yeah, as we know, email threads can vary, but it seemed like here they were saying they're producing that inclusive email if the senders and recipients didn't change. One other thing I'll note: somebody asked about posting the URL of the LinkedIn discussion. I will actually include it in the email that goes out with the slides, so you can certainly check it out then. Plus, I'll also mention that that particular topic is going to be one that I'm going to be continuing to kind of cover in a series. So look for, at least targeted a weekly post to continue that discussion, because clearly we have a lot of people on both sides of the issues. So it'll be fun to sort it out. In the meantime, we'll move on to the next case, where we get into the sanctions portion of our discussion with two wild sanctions cases. In this one that involved claims of unpaid commissions and unpaid business expenses over several years for more than $100,000, the plaintiff's employment was terminated on April 14, 2020. His request for compensation allegedly was made for the first time on May 11, 2020, and his work laptop remained in his possession after his termination in violation of the agreement with the company that the plaintiff signed and company policy. The wiped company laptop and its contents, which the plaintiff allegedly downloaded onto two SD cards, were not produced in Lenovo until June 2nd, 2021. And there were 3 forensic examinations in this case. One that determined that the hard drive of the laptop had been wiped or was brand new. A second, which determined that the first SD card didn't have a PST file on it. And a third that determined the calendar events in the PST file produced with the second SD card wasn't identical to the one on Lenovo servers. Notably, the plaintiff claimed that he didn't know that he would be in a dispute with the defendant until May 11, 2020, when his request for reimbursement was denied, and he said he wiped the laptop clean before then. Massachusetts magistrate, that's hard to say, Judge Judith Dine, stated, as an initial matter, McLaughlin should have known that he would be engaged in a dispute about his entitlement to substantial reimbursements from the moment his employment with Lenovo was terminated at a minimum. Company policy called for reimbursements to be requested within 5 days of the expense being incurred, and McLaughlin was seeking payments going back 3 years. She also said, moreover, the record does not support McLaughlin's explanation for when he wiped the laptop clean, discounting his claim that Windows 10 stopped working shortly after the termination because Lenovo's CISO claimed they had no ability to disable it. As a result, Judge Dine stated, in sum, this court finds that Lenovo has met its burden of establishing that at the time McLaughlin wiped the laptop clean, he knew he was either in or likely to be in a dispute with the company. He was advised immediately upon the termination of his employment to return the laptop. Instead, he wiped it clean. So the sanctions included that McLaughlin was limited to supporting his claims to the calendar entries on the Outlook calendar in Lenovo's system and couldn't use any of the entries from his SD card, reimbursement of the cost of Lenovo's 3 forensic examinations, and a permissive adverse inference instruction sanction regarding the deleted information, but not the terminating sanction sought by Lenovo. So, Tom, given that company policy calls for expense requests to be turned in 5 days of the expense being incurred, and the fact that the plaintiff spoliated evidence, do you think this case should even still be active?
Well, it's a fine line, and I'm sure the judge took that into consideration. Terminating sanctions, dismissing the case are, the most drastic Death Star type sanctions available. And I suspect, I'm sure Judge Peck would comment more on this, that judges are loath to do that absent the most egregious possible behavior. I think the sanctions the judge ordered in your last bullet point there are really sufficient in this case, especially the possible adverse instruction to the jury, which may serve as a death knell But it was getting there. But I think what the judge ordered is a good solution.
All right. Well, let's see what Judge Peck thinks. Judge Stein not only didn't dismiss the case, she also provided a permissive adverse inference instruction sanction instead of a mandatory one. Do you agree with that? And under what circumstances would you opt for a mandatory inference instruction sanction instead?
First, I think there must be something else in this case beyond the unpaid expenses and the 5-day rule. Otherwise, right. I am somewhat curious as to how the case survived. So again, there often is more going on than one can figure out from a judicial opinion. Or it may be that the time for Lenovo to make a summary judgment motion had not yet arrived, and all this about adverse inference, et cetera, may go out the window when and if Lenovo makes a motion for summary judgment saying 5-day rule, didn't ask for the expense reimbursement until X times later, much more than 5 days, case over. As to the type of mandatory inference, a permissive inference lets the jury decide whether to give any weight to the, in this case, destruction of evidence or not. A permissive is you may but need not, and it's in your discretion, assume that the information that was destroyed was bad for Mr. McLaughlin. A mandatory adverse inference, I instruct you, ladies and gentlemen of the jury, that you must find, and the court directs you to find, that the evidence that was destroyed was bad for McLaughlin. That is very, very close to just dismissing the case. So since the magistrate judge was not willing to do the latter, it's clear that's why the court went with the permissive inference, not the mandatory.
Yeah, indeed. So, Mary, obviously we have an uncooperative plaintiff here. So what recommendation do you have for our audience on how to manage discovery with an uncooperative opponent? And what, if anything, could Lenovo have done to make it go more smoothly or at least flush the issues out sooner?
Well, I think they're managing it as best they could. They've got some fairly severe sanctions in this time. It's not terminating sanctions, but I think the only thing they might have done to flesh it out sooner would be to get the opponent on record that he or she has not wiped the devices, so that that's handled earlier. But certainly the a protocol would be a very good thing.
Yeah, absolutely. And certainly a note from the audience that speaks for itself that McLaughlin knew and deliberately deleted responsive documents, so an adverse inference ruling is correct, and certainly couldn't agree more that at least that was warranted. So for certain, we saw some interesting hijinks in this case, and more to come in the next case.
But before we do, one other point, and that is the ordering the plaintiff to pay the costs for the forensic inspections. One always wonders if Lenovo will be able to actually collect that. We don't know the level at which McLaughlin worked for them. We don't know what his financial situation is. There are times when one awards expense reimbursement and it never gets reimbursed because the person doesn't have the money. Yeah.
Oh, great point. Yeah. So that could be more that may or may not come to pass, but certainly notable when you're dealing with an individual plaintiff. So we'll move on to our next case. And that case invokes a phrase we haven't uttered in a while, deja vu all over again. Not just because it's another sanctions case, but last month we covered a different ruling in this case where Oregon District Judge Ann Aiken granted the plaintiff's motion to unseal their motion for sanctions. I said in our webinar last month, or actually the beginning of this month, that I would look for the actual sanctions ruling, and lo and behold, I found it on the exact same day as the other ruling. That was easy. So here the WellPath defendants acknowledged receiving an evidence preservation letter and a tort claim notice from the plaintiffs. Despite those notifications, WellPath conducted 2 email purges. In the first one, WellPath announced most emails, other than emails on a legal hold, would only be retained for 1 year and then permanently deleted, including backups and archives. In a deposition, WellPath's CIO testified that the new retention policy was adopted in response to costs and risks, stating there were discovery risks, such as the case in which he was being deposed. Martin also acknowledged that the potential of bad emails out there was a factor WellPath considered. A second email purge for employees terminated longer than 1 year deleted all remaining emails for named defendant Patricia Sarby, who was the WellPath nurse on duty when Stewart died. Yet the WellPath defendants failed to acknowledge the emails were deleted over several communications between the parties and the court for 2 full years. In considering the WellPath defendants' conduct, Judge Aiken stated, at the time of the first purge of emails in March 2019, WellPath had received an evidence preservation letter, a tort claim notice, and a letter from plaintiff's counsel concerning Mr. Stewart's death. The second purge, which occurred in April 2020, is even more egregious in that it occurred after the WellPath defendants had filed their answer and it deleted the email box of a named party. She also referenced the case Estate of Moreno, which resulted in terminating sanctions, where WellPath did a lot of the same things as this case. She stated, indeed, the facts of this case are more egregious than those of Estate of Moreno because the WellPath defendants initiated a second purge of emails, which destroyed the mailbox of Sabry, a named defendant, after the WellPath defendants had filed an answer and asserted affirmative defenses. Finding intent to deprive, Judge Aiken considered the 4 Leon factors you see there, finding that the first 3 weighed in favor of a terminating sanction, and the 4th factor, which usually weighs against one, did not because the WellPath defendants' actions threatens to interfere with the rightful decision of this case. So Judge Aiken issued terminating sanctions against the WellPath defendants. So, Judge Peck, do you think that a separate case, the fact that a separate case with similar circumstances contributed to the decision to issue terminating sanctions? And would that case have influenced your decision if you were a judge?
I mean, yes and yes. Very similar circumstances, same spoliation occurred, but frankly, I think the timeline here was so crystal clear that even without the Estate of Moreno case, this is a case where 3072 terminating sanctions were appropriate, not a close case at all.
Yeah, agreed. So certainly one of the factors in this, Mary, was kind of what WellPath CIO admitted. So if he hadn't admitted that a partial reason for the email purge was the risk of bad emails out there, do you think they still would have received terminating sanctions?
Oh, you mean like bad emails that they need to produce in this particular litigation?
Right.
Yeah. Well, we've seen it otherwise, that there's been pretty much any excuse not to issue terminating sanctions. But I think even without that, there's a few more factors here. Judge Aiken, I think, is one of the jurists, certainly in Oregon, that holds the government to a higher standard. You know, this is a vulnerable population. Everything was done right in the requests, and there were abysmal compliance with the discovery obligations with that secondary purge of a named witness. So that's just bad.
Yeah, there's a lot there. Plus, not even letting anybody know the emails were deleted for 2 years. So another thing against them.
We have not mentioned my famous Rule 1.1 for quite a while.
This is a good time to do it.
The judge, or the old Watergate, the cover-up is worse than the crime. to not tell the court while all this is going on that, these emails just don't exist because they were purged is really, really egregious.
Yeah, indeed. Tom, I'm pretty sure I know the answer to this question, but I'm going to ask it anyway. Do you think WellPath could have made a more effective argument that it was an oversight in failing to issue a litigation hold on key emails, leading to them being purged, or were they doomed by the other factors in the case?
Well, I'll just say that if we were allowed to do our own slides in this presentation, my slide for this particular topic would be the sound clip from the movie The Color of Money with Tom Cruise saying, "What do you have in your case there?" And the close-up of his face going, "Doom." Everything that both Mary and Judge Peck have stated so far. There was also some, if you read the case order, there's some back and forth about, whether the people at WellPath and the IT department and the people at the jail knew what they were doing. They seemed to be experienced in email preservation and productions. So this wasn't an example of, we just kind of screwed up. I'm sorry. Can I get a mulligan? Claiming an oversight here was going to be very, very difficult to complain. So they were doomed.
Yeah, indeed. Interesting point by Matt Linehan. The case is interesting because it reiterates that the Ninth Circuit continues the pre-2015 spoliation standards with the Leon case factors, which were not for determining whether to enter sanctions, but whether the specific sanction of dismissal, as opposed to adverse inference, was warranted under Rule 37E. He noted other circuits have rejected similar Leon factors entirely, finding those factors to be obsolete and unnecessary in light of Rule 37E's simple intent to deprive standard, which of course was changed in 2015. Anybody, Judge Peck, thoughts on that comment?
Yeah, it's not as egregious as some other use of pre-2015 law by judges, such as, the discovery was not reasonably likely to lead to the discovery of admissible evidence, pieces of the rule that were deleted in 2015. But yes, this is emails that we're talking about. So clearly it's ESI. Can't even make any debate, if it was jail video, is that really ESI or not? Whatever. It should have been a 37E2 analysis cleanly.
Mm-hmm. Yeah, absolutely. And great point. So certainly interesting on that. And we'll move on to our last case, which involves a favorite best practice of mine, illusion testing. And illusion testing is testing the documents not identified as responsive, i.e. the null set, to see if any responsive documents eluded detection.
Is that an industry standard best practice?
Oh, yeah, that's in the industry standard guide you can look up online and find,
right.
Tom. Absolutely. You. So there you go. I wish it were more of a standard, actually, but we'll get to that.
Yeah, should be. Yeah.
Here, in this case, Special Master Philip Favreau worked with the parties to resolve discovery disputes to execute a stipulation and order, which culminated in the 13023 order, which required Deal Genius to redo its production of documents in response to certain of O2 Cool's search queries. In March 2023, Deal Genius produced 54 documents to O2 Cool in response to the 13023 order. The 13023 order required that Deal Genius conduct illusion testing by reviewing a sample set of documents from the null set, which it did, and its null set included over 590,000 documents. Its null set sample contained 2397 documents, and it had identified 2 additional responsive documents from the null set sample that it was producing. The parties had until March 20 to meet and confer to determine if modifications to the search queries were needed. During a conference with the Special Master on April 11, the Special Master instructed O2 Cool that if there were any issues that needed to be addressed, it do so in the near future. O2 Cool subsequently requested an additional search term, and Deal Genius agreed to run the additional search query, which yielded 28 hit documents, all of which Deal Genius deemed relevant upon review and produced. But when O2 Cool requested Deal Genius run a second search term, they refused, arguing that it wasn't connected to the two null set sample documents. The info could have been obtained during fact discovery, which had closed, and that the request was untimely under the express provisions of the 13023 order. Aha! Special Master Favreau directed Deal Genius to run the search term and share the total number of hits, family complete, and the unique hits, which were 50 and 18 respectively, but Deal Genius still refused to budge on production. After discussing legal standards for relevance and proportionality, search terms, and illusion testing, Special Master Favreau stated, the Special Master finds that O2 Cool's request that Deal Genius produce all relevant documents identified in response to the second modified search term is both reasonable and proportional under the circumstances. Reasons supporting the finding included relevance, proportionality, and timing, which Special Master Favreau indicated that Deal Genius waived when it ran the first term, which was past the deadline. He also stated that further illusion testing is warranted, finding that the outcome of the first modified search term raises questions regarding the reliability of Deal Genius's illusion testing results. So, Mary, when is illusion testing appropriate in discovery, and do you think parties are doing it enough?
Well, first, can I just say, Phil Favreau, wow, I just love this. Phil Favreau in an open school case. Love it, love it, love it.
Yeah.
Illusion testing is a wonderful thing to do to ground unilateral search and production procedure that you're going to do. If you haven't agreed with the other side, illusion testing is a wonderful thing to do. I know that it's out of favor, I think, in some information retrieval and statistical senses, but it makes sense. You put yourself in your opponent's shoes. What tests would be persuasive to you that you have done enough to meet your discovery obligations? Looking at what you're not producing, I think, is just a smart thing to do. Belt and suspenders.
Indeed. I'm going to ask Tom a question, but I'll try to. I'm not sure if I made illusion testing completely clear, since someone's asking a question. What does it mean? In essence, what illusion testing means is typically you do a search, you get so many responsive documents. The documents that are not retrieved in that search are not determined to be responsive, or in what's known as the null set. They eluded being detected as potentially responsive. So illusion testing is a sample of that null set of the documents that weren't retrieved, so that you can confirm whether maybe you're missing some relevant documents in your search. And so it's a practice that I've seen in some cases that is providing that kind of additional information to show that, hey, we checked what wasn't retrieved in a search to make sure we're not missing stuff. I hope that helps, and if not, feel free to throw another comment in there. So Tom, when it became clear that the second modified search term retrieved only 50 family complete documents, wouldn't it have been better for Deal Genius to just run them instead of dispute and lead to more questions about their illusion testing process?
Duh.
All right.
I mean, even our old friend, as Mary said, our old friend Phil Favreau said, it would strain credulity for a party to argue that it would be unduly burdensome to review such a limited number of documents. It's 50 documents. Come on, just do it. And then I think they made a tactical error, because he says in your last bullet point there does not appear to be any dispute between the parties regarding the relevance of the documents. And instead they tried to jump on what he called, what was the phrase he used? He had some a novel or a new type of argument, the misconnection argument. Bring up relevance, bring up the fact, as they did mention, but I guess just kind of left it dangling there. Hey, you could have gotten these in fact discovery ages ago. So really, you've just missed the boat. But to try to come up with the misconnection argument as a novel way of going at that, just trying to be a little too clever here, I think. But yeah, 50. If it was 5,000, okay, but
Right.
50. Come on, man.
Yeah. Come on, man. That's indeed. I should have. That's a Tomism. So there you go. So Judge Peck, we don't see many cases where the parties discuss illusion testing and provide results of that testing, especially for cases involving search terms instead of TAR. Why do you think more parties don't do this for defensibility purposes?
Lawyers don't do math. That's the biggest explanation, which obviously illusion testing involves. Moreover, I think most lawyers just assume they've done a great job, or at least a passing grade good job, and leave it at that. And, they don't want to find out they're wrong. So, yeah, I would also point out that if you want to read more about illusion testing, read former magistrate Judge Francis, serving as a special master in the in-ray isocyanates cases. He has 2 or 3 opinions where the parties were fighting over the form of illusion testing, and he ruled on that.
Yeah, absolutely. And you managed to get the word however you pronounce it in again, which is amazing to me. I still can't pronounce that word. So, that's a great walkthrough of the process. Absolutely. One quick comment. Is it not logical that per discovery process, in the event that additional responsive documents are found, so be it? This would include illusion testing, and there are no privileged documents in the production, regardless of the outcome. Search queries can be added to throughout discovery if they're responsive and potentially relevant. It is discovery after all. And presumably a motion to compel was filed to request newly found potentially responsive documents. I'm not sure if it was because they had their agreement and what have you. I think I don't know what was in the 13023 order, but certainly that's a possibility. Regardless, I'm going to move on to our questions, comments, contacts page. And do we have another case law webinar coming up? 10/4. That's not just an affirmative, it's also the date for our next case law webinar.
Doug. Doug.
Come on. Great comments, questions. Yes, I can. One last comment, include a cite to the Judge Francis opinion on illusion testing. I can do that. I believe that's the case we discussed several months back, if I recall. 2 questions on that. So I believe that's the case, and I will confirm that, and I can include that as well. So lots of good stuff coming in the email post webinar today. So with that, I'll say thanks to all of you for your contributions, questions, and comments. And thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary.
Thanks, Doug. And EDRM thanks you for anchoring, Doug, and Tom O'Connor and the Honorable Judge Peck for this insightful presentation. And our thanks to the EDRM community for your kind attention. For those of you with more questions, comments, or a desire to reach out, the engagement tools that Kaylee highlighted at the beginning of the webinar remain active after the close, and we'll see you next time on the EDRM Global Webinar channel. Thank you.
Thanks, everyone.
Yes, thanks, everybody.
Bye, all.